Through you, Mr. Mayor, it is 5:30 p.m. and the live streaming has begun. You may begin your meeting.
Okay, thank you. Councilors, members of SLT, and the public taking in this meeting. We are holding this meeting under the Planning Act on September 11th, 2024, and I call it into session. And the first up is the land recognition statement, which will be read by Councillor Kerr.
Thank you. We begin this meeting by acknowledging the land on which we gather is the traditional territory of the Haudenosaunee and the Anishinaabe peoples, many of whom continue to live and work here today. This territory is covered by the Upper Canada Treaties and is within the land protected by the Dish with One Spoon Wampum Agreement. Today, this gathering place is home to many First Nations, Métis, and Inuit peoples, and acknowledging reminds us that our great standard of living is directly related to the resources and friendship of Indigenous people.
Thank you, Councillor. I turn to the clerk.
Through you, Mr. Mayor, we will proceed with opening remarks. Public meeting under the Planning Act, Wednesday, September 11th at 5:30 p.m. The Town of Pelham is holding hybrid public meetings. A hybrid meeting involves a mixture of in-person and remote attendance and participation. Please note that no decisions have been made prior to this public meeting. The Planning Department will be providing a presentation regarding the subject application. Public meetings under the Planning Act are formal meetings requiring decorum. This means that all comments are to be made through the chair. If you have pre-registered to speak virtually or will be participating in person, you will be given an opportunity to address the committee at the public portion of the meeting. If someone ahead of you has made the same comment that you wish to make, there is no need to repeat them. Please keep all comments concise. If you are live streaming and wish to submit a comment live, please email clerks@pelham.ca. Inappropriate comments and behavior, such as clapping, will not be tolerated. If you wish to receive a copy of the notice of decision, please contact the planner responsible for the application in writing as soon as possible. Contact information will follow the presentation. Mr. Mayor, that does bring you to the adoption of the agenda. I have a motion put forth by Councillor Olson that the agenda for the September 11th, 2024 public meeting under the Planning Act, special meeting of committee, be adopted as circulated. To you, Mr. Mayor.
Thank you, Madam Clerk. All those in favor of the agenda? I see none opposed. Motion carries. And also, after viewing the agenda, is there any councillor that wishes to disclose a pecuniary interest and general nature thereof? Not seeing any, Madam Clerk.
Thank you, Mr. Mayor. We are now on number 5, and I'll read the opening remarks for the subject application into the record. Town of Pelham application for zoning bylaw amendment, Forest Park, file number AM-06-2024. Zoning bylaw amendment to amend the site-specific residential 2-129 R2-129 zone on the property. The Planning Act requires under Section 34 that council must hold at least one public meeting for informing the public in respect of the zoning bylaw amendment. This public meeting has been called to satisfy this requirement. Notice of this meeting was provided by prepaid first-class mail to all persons who are listed as owners in the last revised assessment roll within 120 meters of the subject property on August 16th, 2024. The notice provided information on the property and the proposed draft plan of subdivision and zoning bylaw amendment. In addition to providing this information, we will also receive any comments which any member of the public may wish to offer. If you wish to receive a copy of the notice of decision, please contact the planner in writing as soon as possible. Contact information is available on the town's website and will be displayed on the last slide of the staff presentation to follow shortly. If a person or a public body would otherwise have the ability to appeal the decision of the Town of Pelham to the Ontario Land Tribunal, but they do not make oral submissions at the public meeting or make written submissions to the Town of Pelham before the bylaw is passed, they are not entitled to appeal the decision. In closing, we stress that at this point, no decisions have been made on the proposed amendment or draft plan of subdivision, and therefore any comments received will be considered by council. Mr. Mayor, we do have our town planner, Andrew Edwards, here with us to present this file.
Thank you. Andrew, you have the floor.
Good evening, members of council, members of the public. Tonight's public meeting concerns an application for zoning bylaw amendment for the development known as Forest Park. The property is located on the south side of Port Robinson Road, east of the Steve Bauer Trail, and north of Merritt Road, outlined here in red. The zoning request pertains only to the single detached dwellings within the Forest Park subdivision along the east side of the future Station Street extension, the north and south sides of Walker Road, and the units on the future Page Street. The subject property is currently vacant. Future surrounding land uses in the subdivision will consist of a mix of single detached and townhouse dwellings, environmental protection lands, and the Steve Bauer Trail to the west. For context, the property received draft plan approval and the zoning bylaw amendment approval from council in April of 2022. Final approval of phase 1 of the subdivision was granted in August 2024. The plan is comprised of 71 singles, 87 towns, a future apartment block, a park block, and a stormwater management pond block. The requested zoning bylaw amendment that we are discussing tonight would amend the existing site-specific residential 2-129 R2-129 zone for single detached dwellings within a portion of the plan of subdivision. The requested zoning change would continue to permit the use of the lots for single detached dwellings, subject to 6 new amendments to the special regulations, mostly related to driveway and garage widths, height, and a rear yard setback reduction for one specific lot. Pictured on the slide here is the draft plan of subdivision. The zoning change is proposed only to apply to the single detached dwellings within the subdivision, which are highlighted here in yellow. The following revisions are requested. A revised definition of lot frontage, requesting the garage shall be a minimum of 0.6 meters behind the front face of the dwelling or covered porch, a maximum attached garage width of 50% of the lot frontage, a maximum driveway width of 50% of the lot frontage for the first 6 meters and 60% of lot frontage 6 meters behind the property line, a maximum height of 13 meters, and a minimum rear yard of 4 meters that's only applicable for lot 34, which is shown on the slide with a red star. For some additional context, the reduction to the rear yard is only requested for one singular lot, as I mentioned, lot 34 here, and the grading plan is on the slide here. The request was made given the irregular pie shape of the lot that resulted in a pinch point that could not accommodate the required rear yard setback. The provincial land use planning framework for the property includes being within a designated settlement area per the provincial policy statement. Settlement areas are intended to be the focus of new growth and new development and are to include a mix of uses, housing options, and densities. The lands are located within the designated greenfield area under the growth plan. New development in greenfield areas is to be planned in a manner that supports complete communities, supports active transportation and transit services. According to the Niagara Region official plan, the property is again within a designated greenfield area. The region's official plan encourages a variety of housing types within greenfield areas, encourages sequential and orderly development within existing built-up areas, and supports active and public transportation. According to the town's official plan, the lands are located within the East Fonthill Secondary Plan area and are designated low-density residential and medium-density residential, with the majority of the site being within the low-density designation. Permitted uses in the low-density residential designation include singles, semis, and townhomes. Objectives of the secondary plan include, but are not limited to, ensuring the community is developed with a compact urban form, creating a complete community, and to ensure that all new development is appropriately serviced with full urban water and sanitary services. In addition, all development within the secondary plan area is to be generally consistent with the urban design guidelines. The guidelines are intended to promote an appropriate and attractive built form within the secondary plan area, and generally these guidelines aim to prioritize landscaping and architectural features over driveways to ensure that driveways and garages do not dominate lot frontages and streetscapes, and that new development contributes positively to the streetscape. A previous zoning bylaw amendment was approved by council in 2022. It rezoned the lands as a whole from the agricultural zone to a variety of site-specific residential zones that permitted the uses that were proposed in the subdivision. The zoning bylaw amendment application now requests to amend the site-specific R2 zoning that applied to the single detached dwellings within the subdivision. There are 6 site-specific provisions requested for the site-specific R2 zone outlined in the table here. The first being a reduction in the rear yard requirement to 4 meters from the required 6. Again, this only applies to lot 34, a singular lot. The second request is a maximum height of 13 meters from the required 12. The third is requesting the garage of the dwelling be set back a minimum of 0.6 meters behind the front face of the dwelling or covered porch. This request will still require the front face of the dwelling to be set back at least 4 meters and the garage at least 6 meters from the lot line. It will allow for flexibility in building design. The fourth request is requesting the maximum width of the garage be 50% of the lot frontage, whereas the requirement is a maximum of 7 meters or 50% of the lot frontage, whichever is less. The fifth request is requesting a maximum driveway width of 50% of the lot frontage for the first 6 meters and 60% of lot frontage 6 meters behind the front lot line, whereas the requirement is 7 meters or 50% of the lot frontage, whichever is less. The final request is requesting a revised definition of lot frontage for lots where the front lot line is not a straight line. This change entails measuring frontage from a point 7.5 meters back from the center point of the front lot line, where currently the definition is a point 6 meters back from the front lot line. So what do these changes actually look like on the ground? I put together these diagrams to help visually clarify what the definition changes will permit. The diagram on the left shows how frontage is defined in the case of a lot that does not have a straight front line. These are typically pie lots. The red line shows how the definition reads in the current 2022 comprehensive bylaw. A straight line drawn between the side lot lines from a point 6 meters back from the center point of the lot line. What the applicant is asking for is that the definition be altered to a point 7.5 meters behind the lot line. And this is the blue lot line there. So in essence, it creates a slightly larger frontage that will permit a comparatively wider driveway and garage. The second diagram illustrates how height is proposed to be measured. Currently, height is measured from the average grade of the longest wall to the peak of the roof. This is the red line drawn from that average grade to the peak of the roof. In the previous 1987 zoning bylaw, height was measured from the average grade to the midpoint of the peak, which is that blue line there. What the applicant is now requesting is that height is measured from the finished grade of the ground adjoining the principal entrance to the peak. Several comments have been received on the application from both external agencies and town departments, which are summarized here. Town planning recommended the applicant request a variation to the definition of height rather than a blanket increase for all single detached dwellings to ensure compliance with official plan policy. Town Public Works commented no side yard walkways will be permitted, drainage swales must be kept clear of obstructions, water services cannot be located within driveways, and curb cut and driveway aprons cannot be widened further than 50% lot frontage. Town building had no comments but advised that building permits will be required at a later date. Enbridge Gas had no objection. In terms of technical reports, the following materials were submitted by the applicant along with the application: a planning justification report, as well as a lot grading plan for that lot that's requesting the reduced lot rear yard setback. All of these materials are available for download on the Engaging Pelham webpage. With that concludes my presentation. I thank you for your attention this evening. I emphasize that no decisions or recommendations concerning this application will occur tonight. We will review the comments received and prepare a recommendation for council's consideration at a later date. If any member of the public wishes to receive notices regarding this application, please ensure that you have provided either written comments or verbal comments tonight, or provide your contact information to the clerk as soon as possible. And I'm available for any questions that you have tonight. Thank you.
Thank you for your presentation, Mr. Edwards. I turn to the clerk.
Thank you. Through you, Mr. Mayor, we do have the applicant's agent with us this afternoon, Mr. Godfrey, I believe, is doing the presentation. Excellent. And we do have a presentation. Ms. Legros, would you mind assisting? Thank you.
Great, thank you. I'm Nick Godfrey. I'm a senior planner with Upper Canada Consultants, and thank you for having me here today. And thank you, Andrew, for that presentation. There were some good illustrations in there I think really help explain what we're trying to do here. So I'm here tonight to provide a presentation for a zoning bylaw amendment application for the draft approved Forest Park subdivision. So briefly, the Forest Park subdivision was approved in 2002 for draft plan of subdivision and a zoning bylaw amendment. As part of that application, the lands were rezoned from agricultural to residential, with an additional zoning to recognize the adjacent environmental features. The draft plan also created lots for single-detached townhome and apartment dwellings. The single-attached lots range from about 14 meters to just under 23 meters. So on average, these are larger lots and provide a different feel for size and scale in this neighborhood. The subject lands, as Andrew mentioned, are within a defined urban boundary with existing urban land uses surrounding the property. And from a policy perspective, the subject lands are located within the Fonthill urban area and within the delineated built-up area pursuant to the Niagara Official Plan. The lands are currently zoned R2 Residential 2 with Special Provision 129. Single detached dwellings are allowed under the current zoning regulations, which also includes additional provisions for aspects such as building height, front and rear yard setbacks, and the width of driveways and garages. As Andrew mentioned, the proposed zoning relief we're looking for relates to the town's definition of lot frontage, under advisement of the town as well, revision of the town's definition of finished grades, as well as amendments to provisions for maximum attached garage width and maximum attached driveway width, and a site-specific provision for lot 34. So the intent of the requested zoning relief is minor, but will rebalance the permissions for these larger single-detached lots in the Forest Park subdivision, so that they are not disproportionately affected by the town's zoning provisions. The requested relief aims to streamline the process by obtaining blanket approvals for all lots, rather than individually presenting each lot to the Committee of Adjustment for these minor reliefs. This approach allows the developer to implement their preferred designs more efficiently. Here's an illustration of lot 34. So these examples are taken from the Fonthill area and illustrate the intent for the subject lots. These examples demonstrate how larger driveways and garages can be seamlessly integrated into the aesthetic and design harmony of the house. And they make a positive contribution to the neighborhood's character without adversely affecting landscaping or the streetscape. In these examples, garages are incorporated through design and material selection, where the garage is considered part of a cohesive and unified whole. The garages will continue the architectural choices of the main dwelling through elements such as brick skirting and cladding. The requested zoning relief is in keeping with the overall design and style of homes in the East Fonthill area and are not uncharacteristic of what you'd find in some of these subdivisions that have been recently built in the Fonthill area. Important to note that the same builder you see here for Rosewood Avenue, Rinaldi Homes, will be also building the homes in this intended section of the subdivision. So it's a similar product and similar typology that you see here, where it is the garage is not an afterthought to the house, but is incorporated as part of design choice. And the other thing to note here is that the intent to control garage dominate architecture is so that garages do not dominate the streetscape. If, a clear, coherent, attractive streetscape. However, in streets like this, where you're not dominating with asphalt and pavement, you see things like design intention behind the driveways with brick pavers, decorative sidewalk and decorative edging around the driveways, so that it's not what you see in some areas where you have a dominance black asphalt and tar. It's actually part of the product, part of the design, that you have these attractive driveways that integrate into the coherency of the house. So that's my presentation. I'm available for questions if you have any.
Thank you for your presentation. I turn to the clerk.
Thank you, through you, Mr. Mayor. That does bring us to the public portion of tonight's meeting. We do not have any pre-registered members of the public. However, you are welcome to open up to the floor if you'd like.
Okay, thank you. Is there anyone present that would like to make a presentation to the council on tonight's subjects? I see no one. Going once, twice. We will now close this portion, the public portion of the meeting, to the clerk.
Excellent, thank you. So it is 5:50 p.m. and I have confirmed we've received no emails. Mr. Mayor, you may move on to the committee input.
Okay, thank you. Does anyone on council have any questions for either one of our presenters? Pretty straightforward today's meeting. Councillor Kerr.
Thank you, through you, Mr. Mayor. You made the comment about the driveways and the materials that would be used at that. Does that come in at the building phase? I guess I always look at it, you can say that this is going to be done, but does it necessarily be enforced that it will be done in that particular fashion with this type of zoning?
Through you, Mr. Mayor, to the councillor. So you're correct. There is no hard, fast rule or bylaw that forces them to complete that style of driveway. But this is the same developer that developed the Rosewood Crescent subdivision just north of the soccer club on Rice Road. And so when we went through the original zoning approval, he didn't have Rinaldi Homes at the table at that time as the builder to have that deal put together. Since that time, he has entered into a tentative deal with Rinaldi Homes to build that product. So over the last several months, we've worked with the builder to look at their specific designs that they used in the Rosewood Crescent subdivision. It's a very similar setting. And so that's really the rationale and ultimately the reason why we're here tonight is we've gone through that process with the builder. They'd like to tweak some of the zoning to really keep the same style of houses that they built in the Rosewood Crescent subdivision. So yeah, that's big picture why we're here.
Councillor?
Thank you. Yeah, aesthetics is always a big thing relative to everybody, and it's finding to ensure that the aesthetic part is followed through on. That was really the point of the question.
Thank you, Councillor. Any other questions? I see Councillor Nesnick.
Hi, thank you. Yes, through you, Mr. Mayor, this is probably a question with regards to the concern from Public Works with regards to the no side walkways. So can you just explain how then, like even this lot 34, the pinch point, is that wide enough for a fence to go up and then someone to walk through that pinch point at the front of those homes to the backyard, or how do they access the backyard?
And Mr. Edwards, would you like to field that question, please?
Through you, Mr. Mayor, to the councillor, that comment from Public Works is really related to the swales on the side yards. They typically comment that those sidewalks are not permitted in order to not obstruct drainage from the swales that are designed to for runoff to go to the storm sewers. In terms of accessing the rear yard, a resident can still access from the side yards, but they're just not permitted to have any hardscape features that would obstruct the swale.
Councillor?
So there's space to walk through between that, is it 1.2 meters? I guess, what's that, 4 feet approximately from the corner lot? So there'd be a fence and then the building at the corner. I'm just looking at lot 34 right now. So just wondering if they'd considered putting a smaller home on that lot. So then you wouldn't have to worry about the back being only 4 meters. That pinch point would be back up to 6 if you made the house a little bit shorter and smaller. And then, as I said, they have easements on the one side there. So are there easements on every lot in that subdivision, or just this one?
Mr. Edwards?
Through you, Mr. Mayor, there would only be easements on specific lots where infrastructure is located, not on every single.
Okay. And then can you just explain through you, Mr. Mayor, again, how is that, I guess, overseen over the years? So once a person purchases the property and they build on their home and then they start to live there, and through the years, how do you ensure that that easement is retained and not altered? I'm just worried about drainage. We just had this huge storm the other day and the streets were flooded. So just thinking ahead on that.
Through you,
Thank you,
Mr. Mayor,
Councillor.
I'll respond to that question.
Okay, Shannon?
As part of the subdivision agreement and the registration of the subdivision, those easements are registered, and so there is a legal restriction. At times, we do have people unfortunately construct within those easements. However, the agreement that's registered and that legal registration is still valid, and so we have to follow up and have things removed out of the easement so that things continue to function the way that it's designed. So sometimes it does result in a bit of a legal process, unfortunately, but it's a requirement and it's the best way to inform future purchasers that there is a restriction there and that they're not to obstruct it.
Thank you, Ms. LeBlanc. Councillor?
Right, so just one final question. So is a fence built along there between the two properties, within that easement? Is that allowed?
Through you, Mr. Mayor, typically the easement goes to the property line and the fence is along the property line. And so there is the permission for for the fence on that location. The biggest thing with easements and fences, we get this question all the time, whether people can put a fence in the easement. People do. The challenge is that if we have to come in and do maintenance or something like that, if there's underground infrastructure or something else, then we will remove whatever obstruction is there in order to do the maintenance, and we may not replace it. Okay. So it's at the property owner's risk if they were to erect something like that within the easement.
Thank you. Councillor?
Thank you. That's all, I think.
Thank you, Councillor. Any other questions? Councillor Olson?
Thank you, Mr. Mayor. Through you to the presenters and Mr. Godfrey. Thanks for showing those pictures of the building there, because the houses, that gives me a good idea of what you're talking about. But the pictures that you had there, how wide is those lots, and how wide is the driveway and the garages on those buildings there that you presented?
Through you, Mr. Mayor, to the councillor. Yeah, so those lot frontages are identical to what we have here. There's a bit of a range, so the Forest Park subdivision goes from 14 up to 22 meters in frontage. The bulk of them are 16 or 18. So we're in that 58 to just over 60 foot range. So that's really the same frontages between the two. Now, in terms of the driveways, the Rosewood zoning also restricts driveways at 50% of the lot frontage. So in this situation, the zoning has, I think off the top of my head, 7 meters or 50%, whichever is less. So in the instance where you get lots that are wider than 14 meters, it's not balanced between lots that are smaller and lots that are bigger. So just keeping it at 50% doesn't negatively impact the larger lot for the equivalent amount of driveway space.
Thank you. And another question, Mr. Mayor. It seems to me that these are relatively minor things. They look to me to be, and that's why you're establishing these as a means of efficiency. So are we establishing a precedent that's going to be applied for all things when it comes to height and in the front lot for these pie-shaped lots? And I'll ask that to our planner. Is that what we're doing here?
Mr. Edwards or Ms. LeBlanc?
Yeah, through you, Mr. Mayor. These exceptions that are being requested would only apply to these single detached lots in the Forest Park subdivision. So they would not apply to other lots throughout East Fonthill.
Okay, I guess I'm at a loss for where the efficiency comes in. If it,
It's just for
if
them.
it, if that's the goal, how could, if it only applies for that, is this just a methodology that we're trying to establish here, or what?
Ms. Locke, or,
Are we speaking specifically to the change in the definition? Is that
Well, let's take height, for example.
right? Through you, Mr. Mayor. So the comment from the planning department about the height and changing the definition in terms of how we consider height with respect to those lots, it's more of a technicality than anything. The official plan is very prescriptive in this area with respect to height, and it says that you can have a maximum of, I think it's 12 meters. And so they really aren't asking for an increase to the height of the building. The building's still, for most purposes, going to be 12 meters or 3 stories. Instead, we're just looking at how you're going to consider the height. And with those particular lots, there's a change in grade. So the building really isn't getting higher. It's getting, it's just being measured differently.
Okay, thank you, Mr. Mayor.
okay, thank you, Counselor. Any other questions from committee? Not seeing any, I turn to the clerk.
Thank you, Mr. Mayor. That brings us to the presentation of resolutions. I have a motion put forth by Councillor Wink that committee receive report 2024-189 for information as it pertains to file number AM-06-2024, and that committee direct planning staff to prepare the recommendation report on this topic for council's consideration. To you, Mr. Mayor.
Okay, any further discussion on this item? Not seeing any, all those in favor? See none opposed, motion carries.
Thank you. I have a motion put forth by Councillor Kerr that committee receive the applicant's presentation for information. To you, Mr. Mayor.
Okay, thank you. All those in favor? None opposed, motion carries.
Thank you, Mr. Mayor. That brings us to adjournment. I have a motion put forth by Councillor Niznik that this special committee of the whole public meeting under the Planning Act. To you, Mr.
Okay,
Mayor.
thank you. All those in favor? None opposed, meeting is